Thanks everybody for joining me here today on this webinar. It is about estate planning and getting your affairs in order. We are in a different environment. We all know that. A lot of people are at home, working from home, or this is a different situation. And I think one of the benefits of, when we get shaken up a little bit like we are right now, is it causes us to pause and to think a bit. And I know with the social distancing guidelines, our office is working remotely, though we are able to, meet with people. We have 6-foot guidelines, so we can still meet with people. But it's almost like being separated has brought us more together. And I think it's also caused a lot of us to think about things that are really, really important. Your family, your friends, the people that you love. So what we're going to be talking about today is something that normally we don't really even want to think about. Obviously, as an estate planning and elder law attorney, I do, but most people don't. And what that is getting your affairs in order. As serious as that sounds, it's a pretty important thing to be thinking about. So during this webinar, if you have questions, just go ahead and go to the bottom of your screen and you can do a chat and say what questions you have. And at the end of the webinar, I'll answer your questions. Until then, if you could do me a favor, if you wouldn't mind going down to the chat box and you can just test it out, would you let me know how you learned of this webinar today? Did you hear of it on Facebook or other social media, from our emails, or perhaps from the newspaper, the Spokesman Review? So if you let me know that, I really appreciate it. All right, so we are going to get started. Oh, one more thing. Please make sure that if you can, stay until the end of this webinar. Once I turn off the record button, I'm going to share with you some pretty important information. All right. So I am going to share my screen, and thank you everybody for commenting. I really appreciate it. All right. Let me know by a raise of hands, and I can see some of you. Do you see a screen that says estate planning, getting your affairs in order? Raise your hand if you do. Awesome. Thank you so much. All right. So technology is working. Yes. All right. So let's talk about, first thing we're gonna, this webinar is gonna talk about is wills. Then we're gonna explain a bit more about revocable living trusts. And then we're also going to talk about asset protection trusts. And my goal is to provide you enough information that you at least have a basic understanding of these various estate planning tools, so that you can be in a better place to decide, well, which one is right for you. So just a little bit more about myself. And I've been an attorney for a long time, 34 years, graduated from the University of Washington with my Juris Doctor degree. That's a law degree. And because I am an elder law attorney, it's really important that I am part of the National Academy of Elder Law Attorneys. And I'm also a member of the Washington Academy of Elder Law Attorneys. And I've been on its board. I've been its past president, its past member of the year. So what that means is that my life is pretty much dedicated to helping people with elder law and estate planning issues. AVA is a rating agency that I have a top rating, 10 superb, and Martindale Hubble is the venerable rating agency. And I have AV, which means I am one of only 5% of lawyers with that, female lawyers, that is, with that rating. And I've been awarded Washington's top elder law attorney from the Spokane Coeur d'Alene magazine since '08. Enough about me. So let's talk about my team. Nobody can do anything on their own. Why? So Elder Law Group has a really excellent team of dedicated legal professionals. I don't know if I'd necessarily call Piper and Willie, the Labradors, so dedicated. They sleep most of the time. And we have an office in Tri-Cities, Spokane, and we also serve North Idaho. So, all right. So let's talk about what makes an elder law attorney different. How is an elder law attorney different from other lawyers that perhaps do estate planning? So one of the things that makes us different is that we understand some unique asset protection estate planning tools. So why is that? Why that is because an elder law attorney should be knowledgeable about government benefit rules. And what I mean by that is such benefits as Medicaid, Medicaid's laws and benefits, and Veterans Affairs and their rules and their benefits. So that's something that is unique to elder law attorneys, is actually knowing these benefit rules, because frankly, we file Medicaid applications for long-term care benefits. We understand what the rules are, how to work with the agency, what the requirements are. And so because of that, we know what to put into your estate planning documents so that we can make sure that you will benefit from any kind of government benefits to which you might be entitled to use. And that allows you to protect not just yourself, but your money and your loved ones. So what's the #1 threat to a senior's financial security? I know that all of the financial advisors out there is going to say the same thing. Long-term care costs, by far. That's what people worry about, is how are they going to pay for care if they or their spouse becomes sick. And it's a good question, because care can run $12,000 per month, not per year, per month. So it is something that causes a lot of people a lot of worry. Government benefits certainly can help, and those government benefits are typically Medicaid, because Medicaid is really what I call the workhorse for paying for long-term care in facilities. But keep in mind, it's not just paying for care in a skilled nursing facility. Medicaid also pays for care in an adult family home, assisted living, or even in your own home. Something about Medicaid, though, it's very complex, very complicated. Lots of these rules don't make any sense. So in order to be successful with preparing an estate plan that'll incorporate the possibility for government benefits, you need to know Medicaid's rules. And that is what really distinguishes an elder law attorney from other attorneys, including estate planning attorneys that do not practice in the area of Medicaid benefits. So, well, why are we having this conversation? Well, all of us want to do our part in many, many ways. And one of the first ways that you can do your part is, yes, to take care of those you love. But how do you do that? You take care of yourself too. You make sure that you have a plan in place. Why? Because we know it's important. It's important to you that you have the sense of security and peace of mind, that you've got a good estate plan, and that once you're no longer with us, that you haven't left a mess for your family. And in fact, you've done the opposite. You have left them in a situation where they are secure and money is protected for them. That's what we're talking about today when we get to wills with asset protection. Now, not surprisingly, most people are not prepared. That's just kind of human nature. As you see here on this slide, 51% of Americans who are aged 55 to 64 don't have an estate plan. I know I saw a statistic very, very similar, which was over 50% of lawyers don't have an estate plan, which kind of is stunning, but so be it. A lot of people might have estate plans, but far fewer of those folks that even have estate plans have asset protection built into them. So what's really important? Got to plan ahead. You've got to take the time to understand. If you have an estate plan, fantastic. That's wonderful. I would ask you to go to a step further. Does it provide protections like we're going to be talking about? Planning while you can. What I mean by that, and even though elder law group is a multi-generational, we provide services not just for seniors, but for younger age groups. The planning ahead while you can, why I'm emphasizing that is because when people lose the ability to understand, then they can't prepare estate planning documents. The law requires that there be what we call capacity. So if somebody, and this happens with younger folks, they're in an accident and something happens and they've lost their capacity, they have no opportunity to do any planning. They're going to be under a court-ordered guardianship. So while you and your spouse can, this is the time to really look seriously about taking steps, to protect yourselves, because you're protecting your future. All right, so let's talk about legal documents to protect your loved ones when you are gone. I'm sure that's kind of why people go, why do I even want to talk about this when I'm gone? So I wish I knew of a way to make it a little bit lighter and more fun, but I really don't. All right. Sorry here, let me just find the right page. I don't have this all memorized, so I pretty much go by notes sometimes too. All right, so what do you need? We're going to be talking about wills. We're going to be talking about revocable living trusts. We're going to be talking about asset protection trusts. So let's start with a will. Pretty sure everybody knows what a will is. A will is the legal document that says who gets your assets when you are gone. Sometimes, though, people don't realize, even though it seems logical, that a will takes effect upon a death. So the will is really the estate planning tool that says what happens when you're gone, where do your assets go, who gets them. A will means that if you say where you want your assets to go, then you're not under what's called the laws of intestacy. The laws of intestacy are what the state says where your assets should go. In a will, you can name a guardian for a child, for a minor child. You can set up any kind of trust that you want to protect your beneficiaries, including the kind of asset protection trust we're going to be talking about. So there's a lot of benefits to having a will. So what I want to talk about are what people are most familiar with. I call it a traditional will. And why I call it a traditional will is that it usually is not one that would be drafted by an elder law attorney, because an elder law attorney is always going to be thinking about asset protection, how to use government benefits if they would be available. But nonetheless, it's a really good start to have a traditional will. So who normally drafts that type of a will? Well, normally you go to an estate planning lawyer, and an estate planning lawyer will draft the type of will that they have probably always drafted. And the likelihood is it won't contain an asset protection provision. And the reason for that is that an estate planning lawyer is not necessarily an elder law attorney. An elder law attorney really is, and not all elder law attorneys are familiar with government benefit rules. You really want to be looking for an elder law attorney who knows Medicaid's rules, because we file Medicaid applications and we know what requirements have to be in a will to protect assets and comply with Medicaid's rules. So an estate planning lawyer typically is not going to do that, because they simply don't know what they don't know, because they don't file government benefit applications. Also, each of you could be drafting your own estate planning document. And with the internet, strange as it is today, but with the internet available, you could probably find some online forms, or you could get them at Staples, or you could get them from Susie Orman. I think it's $49.99. $49.99. I mean, so, I mean, there's a lot of reasons that people go, why not just do it myself? I know I'm supposed to have a will. Well, the main problem with doing your own form that you download from the internet is it's a document, but it's not a plan. It is not going to sit down with you, talk with you about what your goals, your concerns are. What are you trying to protect? Who are you trying to protect? How do you do that? It's an online form. So it's not going to provide you any sort of protections. And you know what? There's really no guarantees in life, but I can pretty much guarantee you if you have an online form, you're creating a mess for your family, and that's not what you want to do. I used to be a litigator years and years ago, and I can tell you that litigation is not something that you want to see in your family, and an online form is just a platform for people to be able to, dispute what your will says. And you might think, well, my family gets along just fine, perhaps, but what we do when you do estate planning is you basically plan for what can go wrong and make sure that it won't go wrong because you've got the right estate plan in place. So, an estate plan really needs, at least at a minimum, an estate planning lawyer to draft it. And I don't mean that you should go to the real estate attorney or the family law attorney, because just like anything in this world, there's expertise in areas of focus and practice. You want to go to somebody who knows this stuff, and this is what they do. They don't do every type of law, because you're just not going to have the competency. You're not going to find the competency with a lawyer who does everything. So in the traditional will, you are going to find some protections. They're not going to be necessarily asset protections, but there's going to be protections. So for example, if you want to disinherit anyone who is one of your children, for example, you have to have a will that says, I disinherit that child. If you just fail to name that child, and like you did your online will, what's going to happen is the court's going to say, oh, well, I assume you forgot about that child. Of course you didn't. You didn't want them, but perhaps you didn't know that you have to name your child and disinherit them. And do not say they get $1. It's one of the worst things that people say is they get $1. That gives them all sorts of rights. Don't do that. A traditional will should include a trust for a minor or a grandchildren's trust. So, a traditional will can, is much better than an online form, and it's much better to go to an estate planning attorney than going to a generalist or somebody who doesn't do estate planning. When it comes to the will, and minor children, I said we have a multi-generational practice. The reason that I'm bringing this slide up now, even though you might not think of this as elder laws, this is one of the saddest things that people run into is parents don't plan, they don't have a will, they haven't said who the guardian is going to be for their minor child. And if both of those parents are killed in a car accident, then the children, it's not that uncommon that there will be a fight between family members as to who should be raising the children. And you can overcome all of that by having a will in which you nominate who you want to raise your child in that terrible event that both parents are killed. So again, why are we looking at doing estate planning? We are trying to avoid conflict. We're trying to make sure that your wishes are going to be heard. So let's talk about what happens if you have no will. I mentioned it a moment ago. It's called the laws of intestacy. What that means is the state decides where your money goes. Now, a lot of people say, well, the state gets your money. No, the state usually doesn't get your money. But the state is trying to replicate what you would have wanted had you made a will. So if you're married, your spouse might get all of your money, or if it's a later in life marriage and there's children from a prior marriage, your spouse gets some of your money and your kids get some of your money, which may or may not be what you want. And if you're single and you don't have a will, then it goes to your kids, all of your kids equally. And that also might not be what you want. So that's what happens if there is no will. Now, even if you have a will, a lot of people overlook what are called non-probate assets. So non-probate assets, what are they? Those are assets that your will does not govern. That includes your life insurance policies, your retirement accounts, any financial accounts that you have where you say you direct the account to go to someone, or you share ownership of the account with somebody, for example, joint tenants with right of survivorship. And it also includes direction by account titling, like I just mentioned, a pay on death provision, or a beneficiary designation. Now, why is this important? It's important because a good attorney should sit down, go over all of your assets with you, and make sure that they give you guidance, because just having a will is not good enough. Oftentimes, people's largest asset is their IRA or their 401k, and it does not and should not be directed through your will. There's bad consequences from creditor perspectives, tax perspectives. I mean, you do not want your IRA or your 401k to go to your estate. You want it to pay to people, or if you have a charitable intent, charities. So one of the reasons that I'm kind of emphasizing this is that it's just overlooked. And you know what, if you're doing your own estate plan, you're probably not thinking about the importance of directing your non-probate assets where you want them to go. So really, non-probate assets are the most overlooked piece of an estate plan. Not if it's done by an estate planning attorney, but if it's done by somebody who is a general practitioner, it's overlooked. Okay, so that's, we've been talking about wills, traditional wills. We will get into talking about, asset protection. But before I get there, I want to explain to you revocable living trust, because I'm guessing that most everybody has heard about a revocable living trust. They are heavily promoted by various industries. So what are they? So a revocable living trust is a legal document, and what it does is to manage your assets while you're alive and pass your assets when you are gone. It's a trust you create while you're alive. That's why it's called a living trust. And generally, you and your spouse are the trustee. That means you manage the trust. And you fund the trust. You put your assets into the trust, and then you can take assets out. And then you are also the beneficiary of the trust. So that's really a thumbnail, quick explanation of what is a revocable living trust. So what is the benefit of a revocable living trust? The benefit is that it provides a framework to manage the assets if you can't. So let's say you were to lose capacity. Then a co-trustee or a successor trustee will step up and manage the assets. So there definitely can be a benefit to a revocable living trust. But the main reason people are interested in revocable living trusts is that they are said to avoid probate. And we'll talk about probate, and we'll talk about whether probate is, something that is a good thing or a bad thing. But that's why people have revocable living trusts, is that they have been listened to a lot of pundits. They've listened to, for example, Susie Orman. She is a financial advisor out of California. And in California, revocable living trusts are really good estate planning tools. I'll talk about why they're not necessarily so good in the state of Washington, but the reason that people have them is to avoid a probate. Now, One of the things about revocable living trusts, in order for them to perform like they are supposed to and pass your assets on your death, is that you have to put all your assets that you can into the name of the trust. So that means you need to retitle your house in the name of the trust, your bank accounts in the name of the trust. But you can't put all your assets in this revocable living trust. For example, you don't put your 401k in the trust or your IRA in the trust. And so what that means is that there needs to be a coordination. Consider those 401ks, IRAs, those are non-probate assets. They have to be directed to go where they're supposed to go. So a revocable living trust definitely is an estate planning tool to think about. I'm not saying that they're not. But I want you to know what the downside of a revocable living trust is. One of the main downsides is that they do not protect your assets, at least not in the state of Washington. If you are the trustor, you create the trust, you're the trustee, you're the beneficiary, you are wearing all hats, it's not going to protect your assets. So if somebody sues you, they can get to these assets. The trust does nothing to protect them. So it doesn't protect assets for you while you're alive. And importantly, it doesn't protect assets for your spouse after you're gone if your spouse needs long-term care. Because in our state, in Washington, we have a very specific rule that says if you want to protect assets for your spouse when you're gone, the only way you can do that is through a will. So what I want you to know about revocable living trusts is that they in fact can be harmful because they don't have protections. If you can remove the assets from the trust, well, so can your creditors. And a revocable living trust also is a countable asset should you or your spouse ever need to apply for Medicaid. So we have to revoke the trust, take all the assets out. But worse than that, because we can fix that if you're both alive. Worse than that is if you have a revocable living trust and you are a couple, when the first spouse dies, those assets that are received by the surviving spouse are countable by Medicaid after your death, which means your spouse will need to spend down basically every penny of their money before the state will qualify. Well, before the state will pay for your care, before you would qualify for Medicaid. So that's a big downside of revocable living trusts in the state of Washington. So let's talk about, okay, well, revocable living trust, you said, avoids probate. Isn't that more important to avoid probate? So shouldn't I have a revocable living trust? So what I want to do is dispel notions about probate and whether it's a big, bad, ugly thing or whether it's just a legal process. So it's a legal process to settle the decedent's estate. The decedent is the person who's died. What happens is the Superior Court, we have to file the will with the court. We take it to the court. The Superior Court looks at it and says, yes, this is a valid will, appoints the personal representative. They're also called the executor. That's the person who's going to carry out the terms of your will. And then the creditors are going to be paid. Any creditors that are legitimate creditors are paid, or the claims are invalidated. And then the assets are distributed. So that's what a probate is. Let me see. Hold on, bear with me just a minute. I don't have everybody muted. If I could, I would mute everybody, but hold on. Yeah, never mind. So let's talk then about, well, some people have questions. They said, doesn't probate take a long time? No, it shouldn't. The executor is the person, they get letters testamentary. They are supposed to expeditiously and reasonable time frame settle the claims, distribute the assets. People say, well, it goes on for years and years. It should not go on for years and years. If it does, that's a problem. What takes the longest amount of time in a probate is what we call the creditor's claims period. That's a 4-month period. So we publish a notice in the newspaper in the county where the probate is open, and then anybody who says they have a claim against this estate, they must bring it within the 4-month period. And that gives an opportunity to make sure, are there claims? Then they have to be addressed. If there's no claims within that 4-month period, then we know that the assets are the assets of the estate. Nobody else has a right to them, and then we can distribute them out. So more normal time frame really for a probate isn't years. It should be about 6 months if it's moving forward. And during that creditor's claims period, the executor can, prepare the decedent's house for sale, sell the house, do the estate sale, all of those things. So it's not like the executor can't move forward. It's just that the money won't be distributed until the end of that 4-month period. So all told, it should take about 6 months or so. All right, well, why don't we talk about probate benefits? So, because I'm sure nobody here thinks that there are benefits, and I'm here to tell you that there really are some benefits. Number one, it's the orderly administration of an estate. In Washington, it's pretty simple, it's pretty uncomplicated. People think, oh, the court's involved. The court is not involved. We have what's called non-intervention probate. And what that means is the court signs that first order, and that's it. Beyond that, the court has no involvement. We don't file any document that says the assets of the estate are this, this, and this, and they have this, this, this value. All we do is put in the petition that the assets of the estate exceed the debts by $10,000. That's it. Also, it provides protections against creditors. Make sure your assets go where you want them to go. And key, what's most important really, is that it's only through a probate that you can protect assets for beneficiaries, especially your spouse, especially against long-term care costs. And I'll explain how that works, but first what I'm trying to do is give you a better sense of what probate is. So, should you avoid probate? Well, if there's no benefit to a probate, absolutely avoid it. Lots of times we set up estate plans where we're not trying to protect assets for a surviving spouse or for somebody else, and we set it up to avoid a probate. We don't do it through a trust. There's no need to do that. You can do it through transfer on death deeds on real property, pay on death of bank accounts, beneficiary designations on IRAs and 401ks. So there is a way to avoid probate, simply, if it's appropriate. So if there's no benefit, absolutely we're going to set up your estate to avoid a probate. And if you live in California, which I don't think you do, because if you did, you probably wouldn't be listening to a webinar on Washington wills with asset protection. But if you live in California, where Susie Orman is, then yeah, I'd say avoid a probate. They actually charge a % of the estate for the legal fees. And that's not how we do it here. We do it based upon, well, how much work is involved. And in Washington, we have a pretty simple, easy probate process. So, it's certainly not charged on a fee or percentage of the estate. I think most importantly, though, what I'm trying to make sure that I convey is that if you live in Washington, and if you are married, and if you want to make sure your spouse will never run out of money from long-term care costs or any other threat to money, the only way that you can protect money for your spouse is if you do it through a probate process. The will has to be probated, and it has to contain this asset protection trust in it. So that's why probate might be a really good idea. And I'll show you examples with how it would work. But just, I want you to keep in mind that if you're married and you want to make sure that your spouse does not become poor through long-term care costs, only way you can do it in this state is if you do it through a will that has the right kind of trust in it and that went through probate upon your death. So, okay. So that's wills, at least traditional. We've gone through revocable living trust. We've gone through probate. Now we're going to talk about asset protection trusts. So there are many kinds of trusts that are beyond revocable living trusts. And remember, the revocable living trust does not give you asset protection. But I do want to share with you some other types of trust just so you have more familiarity. There's something called a special needs trust. And usually when we're talking about special needs trust, we're thinking about maybe a child with Down syndrome, or maybe somebody is an adult and they were in a car accident and so now they're incapacitated, they can't work, and but for the money they have, they would receive government benefits. So there is a rule that allows people who are disabled themselves to put money into a special needs trust. It's called a D4A trust. And if they put all their money into that kind of a trust, then they can receive government benefits. There is a downside to special needs trust, and what that is that upon the death of the beneficiary of the trust, rather than it going, the money left in the trust going down to family or children, it goes to the state. So special needs trusts are beyond the scope of what I can talk about today, but I wanted you to be aware of them. Supplemental needs trust is really what we call our asset protection trusts, and we're going to be talking about those in detail. There's also irrevocable trusts. So irrevocable trusts are often used by estate planning lawyers that are dealing with high net worth clients. They have taxable estates and they're trying to follow the tax code and reduce estate tax liability, which, by the way, estate tax liability isn't the problem that it used to be. In the Washington state, you can have just about 2.2 million yourself, no estate tax. The federal limit is over 11 million, no estate tax. So tax planning isn't what it used to be when the estate tax level was down about 600,000. Irrevocable trusts beyond tax planning, though, can be used in pre-planning for Medicaid. So sometimes we have clients who one of the spouses might have a diagnosis, and usually it's not used for spouses. So typically we use irrevocable trust for Medicaid planning for a single person. And those are what we call Medicaid 5-year look-back trusts. That is a way to get the money.
The elder law group.
That's how we get the money out of the person's estate and then put it into a trust so that the state won't count it. But that's after 5 years. And again, that's a whole webinar in itself. I'm not going to get into that. I just thought I should share with you that there are something called irrevocable trusts. Those can't be changed once they're created. They're irrevocable. And then lastly, what we're talking about are testamentary trusts. What are those? Those are trusts that are created by a will. And so this is when we put this together, a will with an asset protection trust. So the will creates a testamentary trust. Upon one's passing, a trust is created for the benefit of whatever the beneficiary may be, whoever the beneficiary may be. All right. So asset protection, estate planning. If the will is set up correctly with an asset protection supplemental needs trust in it, then the assets that are in the trust won't be counted. They will be basically safe from any kind of creditor. The state won't count them. Medicaid won't count them. So when I say it's set up correctly, number one, it has to be in the will. Number two, it can't be like a tax trust, like a cube-tip trust or a bypass trust or all those tax planning terms. It has to be what we call a discretionary trust. Probably giving you too much detail. But the point of it is that it's not just any trust that is in a will. It is an asset protection trust, meaning it's a discretionary trust. Discretionary means the beneficiary can't compel the trustee to give them money. It's up to the trustee to distribute funds as appropriate for the beneficiary. So that's what I mean by it has to be the right kind of trust. So let's talk about the will with asset protection. It protects your spouse after you're gone, so that any money that your spouse would receive from you, if it's in this trust, it is completely protected for your spouse. But it's not just your spouse. Sometimes people have children who would inherit from them, and maybe they have, well, they could be special needs, but let's say that they're not. If they are special needs, you definitely want it to go into this kind of a trust. But let's say that they perhaps are in a bad relationship. You're worried about a divorcing spouse of one of your children, or maybe one of your children has drug or alcohol issues or spending issues. I mean, there's so many reasons why you might want to have this kind of a trust for anyone who would inherit from you, because money in this trust is protected from any type of threat. So really, it is the best tool that you can put into place to make sure that whomever is going to inherit from you will have money and it will be protected. And when it comes to spouses, it is the only way that you can protect money for your spouse when you're gone against long-term care costs. So, you know, we do a lot of Medicaid applications. And I can tell you, we're not the first to jump to Medicaid because we understand long-term care so well and Medicaid so well. But I have to tell you, one of the things that it's important to know and to give people peace of mind is maybe they don't want Medicaid, but at least they might have the option to have it in the situation where it makes sense. So protecting money against long-term care costs is really a key part of what elder law attorneys do. So assets that are received through a will, remember that means through a probate process, somebody has died, the assets are going to go through probate into this asset protection trust are going to be secure. And what do I mean by that? Well, again, what I mean by that is that they are not countable by the state, by Medicaid. They are not reachable by the state, by Medicaid, by creditors. So any kind of threat that you see that might happen to your loved one when you're gone, any financial threat, lawsuits, financial exploitation, taxes, creditors, long-term care costs, you know, all of those are dealt with and mitigated by the fact that the money for your loved one went into this kind of a trust created by your will. So really the benefits of this trust are, for a couple, and I'll explain how this works, you can protect half to 100% of your assets. Funds in the trust don't count if Medicaid, if you're looking to Medicaid to pay for the long-term care costs. And again, it doesn't just protect a spouse, it protects any beneficiary. So I find that numbers are helpful. So let me share with you some numbers. And so wrap your mind around, let's say that there's a total estate of $600,000. And let's say this is for a couple, they live in Washington and they've been married for many years. Everything that they have is joint, is theirs. So what that means is that each spouse owns 1/2 of the $600,000. Hopefully that makes sense. So when one of the spouses passes away and they have this asset protection trust in their will, the spouse who passes, their half is going to go into that asset protection trust because that's the decedent's share. That's where their money goes. That's the money that's going to be protected. Now the surviving spouse, their money, they own half the estate, so their money is going to be outright. They own it. They have control over it. But what they don't have control over is what is put into the asset protection trust. So let me give you a little bit more detail on my example. So let's take Paul and Joanne, and let's say that they have planned for each other. They have a will with asset protection. And as we know, Washington is a community property state. So if they have 600,000, Paul owns 300 and Joanne owns 300. So let's say they've been married for 50 years. Paul's in pretty poor health. Joanne has dementia. You know, when they're living together, they might just get along. They might get along fine. But we know that things are going to change when one of them passes away. If Paul is the one who passes first, especially, Joanne is going to have a problem. So here's how the will with asset protection works. It's husband and wife, they each own 50-50. So asset protection we're going to get is 50%. Paul passes away. Like we thought, Joanne is going to need to go into care. So because Paul and Joanne have this asset protection trust put in their wills for the benefit of each other, what happens when Paul passes away is that his 1/2 of the estate is going to go into this trust for Joanne that his will creates for Joanne. That means that nobody can exploit her, the state can't touch it, Medicaid doesn't count it. It truly is secure and protected for her. So $300,000 is in the trust because Paul's share, he died first, his half goes into this trust. Of course, as I mentioned, Joanne still has her other half outright. So we get $300,000 asset protection. Now don't get bogged down in, is it $600,000 estate, a $400,000 estate, $1 million estate? It doesn't make much difference. What we're talking about is half of the assets, that being the deceased spouse's share, are going to be in a trust for the surviving spouse. And what that means is that surviving spouse will never become impoverished because they will always have that money in that trust. It's there for their benefit. They can't be their own trustee. Usually a family member is the trustee, but it's there for their benefit. And if it's appropriate, if it makes sense to bring in Medicaid benefits, then we'll be able to do that regardless of what is in the trust. We have to look at Medicaid's rules for what the surviving spouse can have in her name, but this money in the trust is not going to count. Now, sometimes we can get 100% asset protection. How do we do that? If we have the situation where Paul is getting sick and we know he is likely to pass away soon, Joanne can give her assets to Paul. And if he does that, if Paul owns everything, when he dies, then $600,000, the entirety of their estate is in this trust for Joanne. And then you might say, but how do they do that? You said Joanne had dementia. Right. But you see, they executed estate planning documents prior to her having dementia. They didn't wait till it was too late. And part of the estate planning documents, and not ones that we're talking about today, are called durable powers of attorney. And under our durable powers of attorney, we give Paul, or anyone who is Paul's attorney, in fact, the ability to take all of Joanne's money, execute a separate property agreement, and give it all over to Paul. So that if we know that Paul is going to be dying, it could be either spouse, it could go either way, then we get 100% asset protection. So because when Paul died, he was the owner of all of the assets of the estate, then there's 100% asset protection for Joanne. And actually, because all the assets now are in the trust, Joanne qualifies for Medicaid without any kind of spend down. Again, I don't want to get too focused on Medicaid. This is not just all about Medicaid. It's about protecting assets for your spouse. But one of the big things that we are always mindful of is what can we do to protect the surviving spouse. So this presentation today isn't about Medicaid. Just going to share with you enough that you understand that Medicaid has really strict financial rules for a single person. And a widower is a single person. And the rules are that that person can only have $2,000 in countable assets. Fortunately for our couple, because they did asset protection estate planning through their wills for them, Medicaid is not going to count whatever is in that trust, be it $300,000, $600,000, whatever is in that trust, Medicaid doesn't see, they don't count it. So the surviving spouse will qualify for the state to pay for benefits, even though they have this nest egg set aside for them. So that's one of the primary reasons, people are concerned about long-term care costs. We do want to make sure that you can feel comfortable knowing that your surviving spouse is never going to be left impoverished. That's one of the reasons that we want to see a will that has asset protection in it. But that's not the only reason. As I mentioned before, beyond protecting money from long-term care costs, there's creditors, there's taxes, there's the state. But as you can see from that really cute picture, it's also to protect the estate from what we call unintentional disinheritance. And as you might be able to see from this picture, what I mean by that is remarriage. So imagine that the couple did not have an asset protection estate plan. Imagine that they just went to a traditional estate planning lawyer and they didn't have this kind of trust set up in the will. Because one of the benefits of having this trust set up in the will is that that money is going to go when the surviving spouse dies. The first spouse dies, we create the trust for the benefit of the survivor. That money is protected. But when that surviving spouse dies, that money is going to go where the first spouse said they wanted it to go, which is usually down to the kids, for example. So if you don't have the kind of estate plan I just talked about, then hopefully nobody is put out too much by this slide, another one that's intended to make you smile. Meet Jacqueline, your husband's next wife. If the wife dies first, then what happens? Well, the surviving spouse has all the money. I have the spouse dying first, the wife dying in this one. So the husband has all the money. And then somebody else moves in, and she moves in, and eventually there basically is a remarriage. And then guess what happens when, let's say that this husband dies, and Jacqueline now is the spouse, and this is what we call a traditional estate plan, a remarriage, unintentional disinheritance. When he dies, Jacqueline gets everything, and what that means is your kids get nothing. And usually people don't like that result. So that's what I want you to know, that there are steps that you can take to protect your money, protect your family, and that's, my goal is to provide you more information. I think knowledge is power. And I think knowledge helps us all. And I think that it's important to be, to people to talk straight about things, and especially about getting your affairs in order and doing what you can to protect, your loved ones. And of course, there's a benefit for you. I just love this picture. It gives you peace of mind. I think why I love it is I think all of us at heart know that we are very, very young. We're like the ballerina, even if our body in the chronological age says something different. So, okay. All right. So let me go ahead and see if I can find your questions. Erica might need a little bit of help finding those. Let me click over here. All right, I'm gonna stop sharing my screen, I think is what I need.
Lynn, if you click the chat box at the bottom of your screen, it'll pop up to the right. Looks like we've got one from Connie Brockerman.
Mm-hmm.
Would you like me to read it to you?
Please, because I think I have to just stop sharing, then I can read things. Okay.
Absolutely. So she asked, does all money in special needs trust go to the state or just enough to repay what the state has spent?
Great question. So if we have a special needs trust like that D4A trust, not the kind that's created by your will, because remember, the will has no payback to the state. If we're talking about a D4A trust, any money that's left first at the time that the beneficiary of the trust dies, that special needs trust, it goes to the state, but only to the extent of benefits that the state has paid on behalf of the beneficiary. So theoretically, there could be some money left to go to beneficiaries, but the state has the first grab on it. Let's see. All right. So
we've got another one.
I got that one. Is the
Awesome.
asset protection trust irrevocable? I think that's what it means. So when a trust is created by a will, what that means is that the person has died, and so since they've died, the trust they create is irrevocable. What that means is that it cannot be changed. So it is irrevocable. So it is an irrevocable trust at that point in time. What happens to assets when both husband and wife pass? Depends. If they both die at the same time, then it's going to go to their alternate beneficiaries. Let's say they have 3 kids. Let's say the 3 kids, 2 of them are perfectly capable, 1 isn't. So, that 3rd kid who needs protections, the money could pay to that child as well. So the trust can be used not just for, not just for a spouse. Let's see. So let's say what we've been talking about is what happens when one of the spouses dies. Well, what if they're both alive? So when they're both alive, that is a complete different webinar, and it's on about how we can qualify one spouse for Medicaid. Medicaid has more generous rules for spouses than it has for single, and Medicaid allows things called a Medicaid annuity. So there's a lot that we can do to protect assets while both spouses are alive. It's not through the will, but it's through the fact that we have good durable powers of attorney. We've done an estate plan, so we can take steps to qualify one of the spouses for Medicaid while both of them are alive. So another question, how long does it take to get your will done? Generally, we like to see a 4 to 6 week turnaround from when we first meet with the client until when it's executed. One of the problems is, for me, it's really something that really troubles me is when people go and they come meet with us and we prepare their estate plan, and then it's delayed for whatever reason, and it's delayed for perhaps months and months and months. You see, until you execute your documents, there are no protections. And so it's really important for me that we move our process through, not by any means a rush, but to get it done, because until it's done, it weighs on you, it weighs on me until it's done. And frankly, we've had clients who have delayed their process and they've died. And what that means is that the plan that they told us they wanted wasn't in place. And so the result wasn't what they wanted. And I think that that's really sad. If you don't have children and no family, who are likely to be good executors? Yes, there are people for such roles. There are professionals who will serve as executors, and it really depends on the value of your estate. Certain banks, I know Washington Trust Bank, they have a trustee department, Northwest Trustee and Management Services. They do professional personal representative duties. Typically, though, they like to see at least a $500,000 estate in liquidity. There's other people who are professionals like accountants and such, and they will do it, and there's not that liquidity requirement. Is the Asset Protection Trust a way to avoid the Medicaid 5-year look back? Yes. So this Asset Protection Trust we've been talking about has no 5-year look back. Why is that? Well, because one of the spouses has died. There's no look back with a death. So this question shows a lot of knowledge, because the person who's asking the question knows that Medicaid has a 5-year look back rule. What that means is you can't take your assets and give them away to somebody and then say, okay, I'm within the resource limit now, please give me Medicaid. Medicaid says, have you given away any money in 5 years? And when we fill out a Medicaid application, we do so, as transparent and candidly. We tell our clients, we tell the state what has happened. And if they've given away assets, then Medicaid is going to impose what's called a period of ineligibility. None of those rules apply for the will with asset protection. There is no look back on that. So next question, if a beneficiary of an IRA is the executor of the estate, that person gets all the money, or do they need to distribute it according to what's outlined in the plan for the estate? Great question. So this is really something that people get confused about. The will can say I want everything to go to my 3 kids. And whatever goes under my will goes to my 3 kids. The IRA, if you want that to be the result, should say it pays to my 1, 2, 3 kids, equally separate accounts. But what if the person didn't know that and they said, oh, I'm just going to have it paid to my executor so that they get 100% of it? Well, now the executor, that person, maybe it's one of the kids, owns 100% of that IRA. And if they want to share that with their kids, that with the other kids, their siblings, that's a big problem. How are they going to do that? Are they going to liquidate it, pay all the taxes associated with the IRA? So yeah, the problem is that under, if you are the executor, you get the IRA and it's paying to you as a person, it's yours. It's not anybody else's. If an IRA pays to an estate, that's also a problem. We don't want it to pay to the estate. If it pays to the estate, yes, then it'll go under the will and it'll be divided 3 ways, for example, if you wanted it to go to the 3 kids. But you see, then they have to take out their taxes on required minimum distributions within a 5-year period. Whereas if it had paid outright or to those 3 under a beneficiary designation, it would be a more favorable 10-year payout. So really good questions here. Appreciate and all of your time and patience as we went through this today. And again, if you have any questions, call us. We're at 509-468-0551. So again, thank you, and everybody stay healthy.